The 10th Circuit upholds another kind of domestic violence restraining order gun ban, and the ATF announces several reforms. That and more on this episode of The News Update.
No, the devil's got no hold on me.
All right, ladies and gentlemen, welcome to The News Update. That's right, the voice you are hearing first this week is Reload founder Stephen Gutowski instead of our wonderful contributing writer Jake Fogelman, who, because he has the week off, he's on vacation. And so he'll be back again shortly to resume his hosting duties and to make this podcast more than just a monologue. Although I think, if I'm being honest, I monologue too much on this particular podcast to begin with. So apologies for that. But this week we are going to be looking at some of our most recent stories, some of our biggest stories, as well as a couple of links from outside of the Reload. And we also have, to break up my monologuing, another featured segment with ASP, or Active Self-Protection. We have Mike Williver on the show at the end. So look for that. We're going to talk about one of their recent videos and just, give you guys a connection to another company that takes a similar approach to making firearms content as we do, but in an area that we don't cover as much, which is self-defense videos, or in this case, police-involved shooting videos. So tune in for that at the end. But to start things off, we're going to be talking about a new ruling out of the 10th Circuit that actually dovetails with the Supreme Court's most recent Second Amendment ruling in United States v. Rahimi. If you recall, that case was about domestic violence restraining orders and the associated gun ban and whether or not that was kosher under the Second Amendment. The Supreme Court ruled 8-1 in that case that it was. However, they were just looking, this was an as-applied challenge, right? And it was only challenging the specific restraining order that was associated with Rahimi himself, and that there are actually two kinds of restraining orders that can bar someone from receiving firearms while they're under or possessing firearms altogether while they're under those restraining orders. And this case out of 10th Circuit deals actually with the second kind. There's a case called U.S. v. Gordon. And the difference here between Gordon and Rahimi is that Rahimi's restraining order was issued after an actual finding that he was dangerous, an actual determination of that case, that he had committed a number of acts that of domestic violence, and that's why he had the restraining order issued against him. Whereas in this case, and it's really two cases that got combined together, but the plaintiffs here are claiming that their restraining orders came from the second type covered by federal law, which just sort of essentially tells the subjects of the restraining order not to commit domestic violence, rather than having an actual finding that they had previously committed acts of domestic violence. So that's the key distinction. And this was actually a distinction that was at issue in Rahimi. The court did not go into whether or not this second type of domestic violence restraining order is constitutional under the Second Amendment. They just focused on the first type and didn't opine on it, but it was at issue in some of the briefs. We had a podcast episode at the time with David Kopel from Independence Institute, who had filed a brief in that case where he was specifically taking issue with this second kind of restraining order here. And it did come up in, I believe, in Thomas's dissent and in oral arguments. So this was something that was part of that case, but not in the core holding of the Rahimi decision. And so here you have the 10th Circuit looking at this question in particular. And they decide essentially that the distinction doesn't matter. Here's a quote from Judge Harris Hartz, who wrote for the majority in this case. As in Rahimi, defendants utterly failed in that endeavor because the orders issued in their very own cases are constitutionally sufficient. He's talking about this facial challenge. It's a facial challenge. It's not an as-applied challenge. But, quote, Utah courts ordered both defendants not to possess firearms, and a Utah court can issue such an order only if it finds that the respondent's use or possession of a weapon may pose a serious threat of harm to the petitioner. So essentially they're saying this distinction that exists in federal law between these two types of restraining orders doesn't exist in practice, that there was really no practical difference because under state law, now these are two cases originating from Utah, they're saying, and this actually came up in the Rahimi oral arguments as well, that basically state laws to issue these sorts of restraining orders, they require judges to find that the person is an actual threat to the petitioner, generally based off of their, actual real world history. And both of these defendants in this case had been accused of incidents of domestic violence. Here's a second quote that gets to that point. Quote, this difference, however, is of no constitutional import, at least on a facial challenge. Rahimi allows a court to disarm a threatening individual if it makes a judicial determination that the individual poses a clear threat of physical violence to another. CI, that's the section of this federal law that was at issue in Rahimi. CI satisfies this requirement through an express finding. CII or C2 establishes the same point, but by reasonable inference from the fact that a defendant is subject to an order prohibiting such behavior. So, effectively this 10th Circuit panel determined that there's really not much practical difference between these two sections of federal law as far as, the different kinds of domestic violence restraining orders. And they sided with the government against these defendants and said that their Second Amendment rights are not being infringed because of these restraining orders disarming them. So, that sets up potentially, a future Supreme Court case here that, if the court wants to disagree with this lower court finding, right, if they do actually, if a majority does see a distinction between these two kinds of restraining orders, domestic violence restraining orders, that certainly they now have the potential to intervene here. But they also could just not take this case and allow it to be good law at the lower levels, potentially signaling that they agree with it, although that's not always what a denial of cert means in these cases, of course. So it's just, that is something that deals directly with a lingering question, I think, from the Rahimi decision on this specific issue, these domestic violence restraining orders and the gun bans that are associated with them. And it's the first I've seen an appeals court get into this question. So significant development. And I will say as well that this ruling does allow some potential future challenges where that based on some very specific set of circumstances, there were some claims brought here that they didn't think were material to the case, but said there may be some circumstances where nonviolent acts that include digital harassment or voyeurism were some of the things that are included in this domestic violence statute in Utah. So technically there are some things you can do in Utah that are classified as qualifying you for a domestic violence restraining order that aren't actual acts of violence or threats of violence, is sort of what they were getting at. So the panel here left open the possibility that people who are subject to domestic violence restraining orders for those reasons may have a better chance of winning an as-applied challenge. Here's the quote on that. Quote, perhaps there could be a domestic violence protective order in Utah that satisfied II, but was not based on implicit findings that could satisfy CI, although we do not see how that could be the case with a proper order restricting possession of firearms, as in the orders at issue here. But defendants cannot prevail on a facial challenge by invoking possible outliers that might raise constitutional concerns. So, that kind of sums up, I think, the bottom line of this ruling. One, they didn't really see a practical distinction between these two different domestic restraining order categories in federal law, because they say in practice they're basically the same thing. You have to, in order to issue a domestic violence restraining order that restricts somebody's gun rights, this court felt that judges are required to find that the person is an actual threat, and that is based on their record of threatening or carrying out acts of violence. So, that they basically didn't see a distinction in practice. And they seem even pretty skeptical that while the Utah's domestic violence restraining orders can be issued based on non-physical threats or not violence, that in real life that would actually happen. And then two, it didn't matter anyway, because these weren't as applied challenges. These were facial challenges. So as long as there are circumstances where these second kind of domestic violence restraining orders are issued because of actual threats, that's enough to satisfy the constitutional requirement under Rahimi, is what they came to. So I think a pretty substantial case that follows up on Rahimi and sort of builds on that case law at the federal appeals level, and one that, if there is a majority on the court that does see a distinction between these two kinds of restraining orders, this is perhaps an opportunity for them to take that up and limit what they'd held in Rahimi. But I think it's probably more likely that most justices agree with this ruling, but we don't know for sure. Anyway, speaking of Supreme Court, I have an analysis piece out that members of the Reload can go over and check out, that deals with another case from federal appeals level. This one we talked about, I think, a week or two ago. It's called Duarte, and it's out of the Ninth Circuit. It was an en banc panel of the Ninth Circuit, which dealt with Stephen Duarte's, I don't know if I'm pronouncing that right, so apologies to this defendant if not. But this is somebody who is technically a nonviolent felon. He has a number of, I think, he has 5 felony convictions on his record, including a previous one for felon in possession of a firearm. He was arrested and charged with a felon in possession of a firearm again years after his first one, and after collecting several more convictions. And the Ninth Circuit found that his gun ban is not unconstitutional. It upheld the charges against him. Now, the Ninth Circuit in this case, I think, more or less just argued that all felons can be disarmed. It doesn't matter if they're violent or nonviolent. That's not what matters in the Ninth Circuit's analysis of the Second Amendment rights at issue here. For instance, here's a quote from their ruling. Judge Kim McLean, Wardlaw, wrote, together these repeated and consistent assurances make clear that felon in possession, she's referring to dicta in Heller and Bruin and Rahimi, where they talk about, especially Heller talks about longstanding prohibitions against felon possession of guns is not implicated by the Heller ruling. They're pointing to instances in these Supreme Court cases where the court has at least assured that the felon in possession laws are not being wiped out by their rulings. So anyway, that's taking it together. These repeated and consistent assurances make clear that felon in possession laws are presumptively constitutional, demonstrating that our holding in Bong Axe, apologies for that, remains consistent with the Supreme Court's articulation of Second Amendment rights. Further, these assurances recognize a historical tradition of firearm regulation that supports categorical application of 922G1 to felons like Duarte. So that's, essentially, it doesn't matter what his actual record was. It's more just the fact that he's a convicted felon, and the legislature, the government has determined that felons are not allowed to own guns, and therefore there's nothing in Heller, Bruin, and Rahimi, according to the Ninth Circuit, that would make them want to change their mind on that idea. So essentially, they're just saying we don't need to consider whether or not violent felonies are required or nonviolent felonies for us to uphold this restriction. So it doesn't, I don't think it gets at the core of what the Supreme Court has been getting at, especially in Rahimi, where they talk quite a lot about this idea of dangerousness. The government in that case, which at the time was the Biden administration, had argued about this idea that that there's sort of a law-abiding or responsible standard for who can and can't be disarmed, and the court was very resistant to that concept right at the time. And if you read the oral arguments, they go on at length about this idea that the government wants to be able to disarm anybody it doesn't think is responsible or law-abiding, and there's a lot of problems with that because that's extremely vague and broad standard. Roberts and Kavanaugh and Thomas and a number of the other justices, I think Barrett as well at one point, bring up this point. And the government actually, in that case, the DOJ, backs off almost immediately from trying to claim that there's some sort of responsibility standard, and instead moves towards what the court seems to prefer, which is this concept of dangerousness, that somebody has to actually be dangerous in order to be disarmed. Now in Rahimi, in that case, they're just talking about a temporary disarmament. That was another key holding, in the final opinion. But their main takeaway, and what they repeat several times in Rahimi, is this idea that, and I'll give you a quote from Roberts, from the actual opinion. He says, quote, "When an individual possesses a clear threat of physical violence to another, the threatening individual may be disarmed." And then he goes on and says, "It's prohibition on the possession." He's talking about the domestic violence restraining order, gun ban under federal law. "It's prohibition on the possession of firearms by those found by a court to present a threat to others fits neatly within the tradition the surety and going armed laws represent." So they're pointing back to these historical laws, and that's their throughput that they see, is this idea of somebody who is a threat of physical violence to another. That's their base level determination for who can be disarmed. So they get into, in oral arguments as well, this concept of they bring up a well-known case that we've talked quite a lot about, right, on the show, which is called Brian, which is filed by a plaintiff named Brian Range, who had lied in the 90s about his income in order to get food stamps. And that because of the way that is punished under federal or under state law in Pennsylvania, he qualified as for this prohibition for felons, even though it's technically it was a misdemeanor, but it's punishable by more than 1 year in prison. So by more than 2 years. So even though he didn't spend any prison time in prison, it still qualifies just under the way these laws are written. So, somebody like him, he's even brought up by name by Barrett in the case. And they ask, maybe Rahimi, who had been accused of, numerous violent crimes, and including shooting at his girlfriend. In fact, Roberts at one point makes kind of a joke in in oral arguments where he's talking to Rahimi's defense lawyer, and he says, what's dangerous, and the defense lawyer is not agreeing necessarily that Rahimi is dangerous, and but he makes a joke about, quote, well, it means somebody who's shooting, at people. That's a good start. So they don't really flesh out exactly what it means to be dangerous in Rahimi. And we don't have a full understanding of that from the court, but we have some indicators, especially in Rahimi, where we talk about, or where they're talking about, violence, violent threats. And Rahimi, they give the example of he actually shot at the mother of his children, actually. So Roberts was basically like, well, obviously this guy is dangerous, but they don't get much further than that. And Clarence Thomas seems, fairly skeptical of the whole dangerousness standard, because he's comparing some of these laws that they're pointing at from the founding era to basically the dangerousness in a lot of these historical traditions, especially pre-American traditions, were really just excuses for tyrants to disarm their political opponents and oppress people. Is sort of Thomas's point for a lot of this dangerousness idea. Although he does seem to concede that even Thomas is saying, he says, quote, this case is not about whether states can disarm people who threaten others. States have a ready mechanism for disarming anyone who uses a firearm to threaten physical violence, criminal prosecution. So, even he is clearly okay with this idea of disarming people who are a violent threat. And then Barrett, and I won't go into my entire piece just because it's very long and detailed, so people should head over to the Reload and read the full thing. But we do get a little more insight from Justice Amy Coney Barrett, because she had ruled on a nonviolent felon case before she joined the Supreme Court back in 2019. There's a case called Cantor v. Barr, where Barrett was actually in the minority. She was she dissented in a 2-1 decision that upheld the conviction of a nonviolent felon for his his gun ban. And she got she probably has, I think, of all the justices, the most detailed record on this question. And her, she also comes to this conclusion that violence is sort of a key metric in whether somebody can be disarmed. However, not the only thing, right? A record of actual violence is not necessarily the only thing. Just to give you one quote here, she says, the historical evidence does, however, support a different proposition that the legislature may disarm those who have demonstrated a proclivity for violence or whose possession of guns would otherwise threaten the public's safety. This is a category simultaneously broader and narrower than felons. It includes dangerous people who have not been convicted of felonies, but not felons lacking indicia of dangerousness. So, where would these people, where are they going to come down on somebody like Duarte, who his convictions include drug dealing and fleeing the police in a car. So it's sort of a car chase conviction. And then, things like vandalism and essentially running from the police. He's got a couple of arrests for running from the police, and then felon in possession of firearms. So that's his criminal record. It's pretty lengthy. It spans over several years, really over like a decade of time. And does that indicate that he is dangerous? These are not technically violent crimes, right? But it's not. There's questions like range, where somebody lying to get food stamps is probably not going to be considered dangerous under any of these standards. But and then somebody like Rahimi, who has shot at his mother of his children and committed a bunch of violent crimes, or at least been accused of a bunch of violent crimes. He was waiting charges for other. He sort of had like a whole crime spree. That was when he got arrested for. That's how they found his gun, because they arrested him for this crime spree. But so somebody like Rahimi is pretty easy case, at least on finding a dangerousness and violence. And then range is on the other end of the spectrum, perhaps, where it's hard to argue that somebody's dangerous because they lied about their income to get food stamps 30 years ago. But where does Duarte fall on that to the Supreme Court? And that's what we don't know. And that's what I think would be a much more interesting case to see them take up. Is he too dangerous to own guns, even though his criminal record does not indicate violence? And there's a few more lower court rulings I think that I have in this piece that go over this. One that dealt with, where a judge threw out a charge against somebody who had actually killed someone, convicted of manslaughter during a bar fight, but it had been decades prior, and he'd served his time, was out of prison, and it wasn't clear that he's still a danger. And then there was another case that actually develops a sort of test for this, a three-pronged, three-category test for this, where they upheld the conviction of a felon, and then they somebody who committed armed robbery, and they said that was a violent felony, but also gave sort of a standard for how to look at it that may be something the Supreme Court adopts down the line. And so you can read the full piece to get those ideas. But I also think the biggest question of all, perhaps, is whether the Supreme Court would take up a case like Duarte. They don't seem eager to do this. They don't seem eager to even take up maybe a easier one of these. The range. First of all, DOJ under Trump is now trying to keep them from taking these cases up. They're recommending not taking felon in possession cases to the Supreme Court, which is the opposite of what the Biden DOJ had done. And then also they didn't appeal range. So, range won his case at the lower courts, but it's not likely to get to the Supreme Court now because DOJ is not appealing it. And then the Supreme Court itself has denied several felon in possession challenges recently. So they don't seem all that eager to expound on what they wrote in Rahimi, at least not yet. So we'll see what happens there. But a lot more in the piece. I feel like I went a little long explaining it, but there's a lot more in the piece. We also had a couple of reforms that the ATF announced this week. They announced a replacement for their zero tolerance gun dealer inspection policy, and they actually even invited people who had their licenses revoked under that policy to reapply, with the idea that maybe they were unfairly targeted. That's obviously been the complaint of the industry, especially the National Shooting Sports Foundation during the Biden administration was saying, things like minor paperwork errors led to revocations. Revocations did climb significantly to, decades highs during the Biden administration. So there was significantly more action on that front. And, the ATF released a whole bunch of new guidelines for how to handle dealer inspections and potential revocations, when to actually go to a revocation. And they're relying a lot more on the concept of a willful violation over, essentially a paperwork error. And they have written out definitions of what willful means. They've put in place, I guess, the Trump administration's new guidelines, replacing the Biden administration. So although the Biden administration, the ATF had said that they'd given up on enforcing the zero tolerance policy last year after a lawsuit over it. So, how much of this was already in motion, we don't know. But the new policy is in that piece, and we got all the details on what it does. We also saw from the ATF another move that appears to be the result of President Trump's review that he had ordered back in February. This one deals with what are called Brady permits. So the the Brady bill, which established the background check system, allows people with certain licenses or permits to bypass the National Instant Criminal Background Check system when purchasing firearms. And generally speaking, these have been basically concealed carry licenses from a lot of states. There were about 28 states before this where their concealed carry license would qualify a holder to forego the NICS check, the National Criminal Background Check System check, during a gun sale, because that's how, because essentially, you've already done the check when you got the permit is kind of the idea here. Although they have a 3-part test for whether a permit fits the definition of a Brady permit. And for whatever reason, this has been an ongoing legal battle for when it comes to Michigan and Alabama's concealed carry permits. The ATF did not want to classify them as Brady permits for the last 6 years, I believe. We're going to actually talk at length about this on the interview podcast with the Gun Owners Foundation, which is one of the groups that sued over this. But anyway, the ATF has reversed themselves on this. It appears to be a result of the Trump administration's review of federal gun policy positions. So now people in Michigan and Alabama who have concealed carry permits there will be able to forego those checks when they go to buy the gun, although an FFL, a licensed dealer, can still require you to go through the check anyway. But so update there. Significant little, only affects a couple states, but it's a pretty significant move. Anyway, just getting on to just a couple of links here before I toss it over to myself to talk with Mike Wilver from Active Self Protection. We have a couple of interesting stories from outside the reload. The first one here comes from WBUR, which is up in New Hampshire, which deals with a new law that they passed to extend immunity for Sig Sauer to lawsuits dealing with the P320, which is kind of a surprise move. Usually, liability lawsuits and protections against them are generally only extended, like in the Protection of Lawful Commerce and Arms Act at the federal level, to lawsuits that attempt to hold gun companies liable for the criminal acts of third parties. This one seems to deal much more closely with the accusations that the P320 has a faulty design or has led to the gun firing without the trigger being pulled. Right. This has obviously been a very hot issue for Sig Sauer over the last several years, and it's only gotten more intense recently. And I think this law is only going to lead to further scrutiny of the company and this particular gun. So we'll keep an eye on what goes on there, what happens with that. But that was kind of a surprising development, I thought. We also had from KOMO in Seattle, a bystander kills suspect who shot 2 victims in downtown Seattle. So there was a shooting where there'd been an altercation and a fight, and then one man shot 2 other people, and a bystander with a concealed carry license shot the attacker and stopped his attack. So, a self-defense story, really a community defense story, I guess, there, a positive use of by a firearm by a concealed carrier up there in Washington and Seattle. So it's something that happens fairly regularly, but usually on self-defense, someone's person, but these do happen occasionally on, in public shootings where you'll see concealed carriers step in and stop somebody from attacking other people. It does happen fairly frequently. So that's another example of one. And then we also had a bit of a controversy in Kentucky, where you had a gun safety group, which was Everytown for gun safety, said that a University of Louisiana student, I think it's U of L, which I believe is I forget which. This was an event at the Kentucky State Capitol back in February. And this speaker named Calvin Polachek, who was he claimed to have survived a school shooting in Pennsylvania, but it turned out, including like some graphic descriptions of his best friend lying in a pool of blood, but it turns out that he was lying. He was not telling the truth. He did not. There was no school shooting at the school he went to. This is a student at the University of Louisville, a graduate student. It appears he just made up this story. And for what purpose, I don't know, but it's pretty awful situation, something to lie about like that. And so the gun control group, which is every town, or specifically, I think the event was Moms Demand Action event, but they're the same group. So they said, they were essentially tricked by this guy. So not a very nice story there. So anyway, that's all we got for the links this week. There's a bunch more, of course, in the newsletter. If you want to sign up for our free weekly newsletter, you should head over to reload.com and do that. You'll get all of these stories and much more, in a lot more detail than I can give in this in this segment before it gets too boring for everybody, right? So, sign up for the newsletter. It comes in every Friday. I got to finish it by Thursday night, right? Every Friday morning. And then, of course, if you buy a membership, you'll get the members exclusive email on Sundays. And you'll also get access to our member exclusive stories. But that's all we've got on this side of the show. I'm going to hand it off to myself so you can hear somebody else talk for a little bit over with me and Mike from Active Self-Protection. All right, we're back with another one of our little featured segments here where we try to talk with folks who do take a similar approach, I think, to gun content, but in a different area of focus than we do. And to that end, we have Mike Williver from Active Self-Protection back on the show. How you doing, Mike?
Very good. So I think what I'll do this week, in lieu of our normal segment over at the Gutowski Files, as we call it, over on our end, I'll probably just send folks over here to watch this little interchange. It's kind of a slow week for gun news anyway, so this works out pretty nicely that I'm on this week.
Yeah, and it helps out for us too, because Jake is on vacation this week. So instead of people just listening to me talk for half an hour, 45 minutes on the news update, I'm glad that we're able to have one of these segments. And I think these segments are always nice change of pace, get people exposed to some other stuff. If you like what the Reload does, you may very well like what Active Self-Protection does. It's different focus, but similar approach. So speaking of which, why don't you just explain for people who maybe the first time hearing this segment or finding out about Active Self-Protection, what is it that you guys do over there?
So Active Self-Protection is a YouTube channel and a company, a training company as well, started by John Correa back in 2011. And currently, we're a much bigger operation than we were back then. I think we have something like 12 or 13 employees, many of them full time. And our mission is to get good, sane, sober, moral, prudent people, good information on training, on what to do, what not to do. We also have a podcast, which is what I do every week, where we interview people who have been in defensive encounters, and we break down sort of their training before, if there was any, the encounter, and then the aftermath, both legal and psychological. So I'm really proud of the Active Self-Protection podcast as well. But yeah, it's a great place to go with a lot of good information, kind of like the Reload.
Yes, absolutely. And but with a focus on the self-defense world. So, something that's complementary but unique and different. And speaking of which, we are going to be going over one of the videos you guys put out recently. Last time we did a video where it was, to be clear, these are not all use of force encounters by police, right? That is a significant portion of what you do, especially when you're in the videos because of your background in federal law enforcement, right? But you guys do all kinds of self-defense encounters, all kinds of shootings, but not even just shootings, stabbings, fist fights, whatever. If people can learn from it in their everyday lives as far as being self-defenders, then you guys, and it's caught on video, which is, I think, a very key part. That's one of the things I've always liked about active self-protection, is that like you're going over real world events that were all caught on video, so that not just hypotheticals, which is what, frankly, a lot of self-defense training, I think, in the past had been built around, is sort of anecdotes and hypotheticals. So it's one thing I always thought set you guys apart. And then, it helps, your good, sober, sane, moral people, as you guys say, right, to defend themselves better, or helps police improve their techniques as well. Last time we talked about a good shoot on video and why it was a good shoot, even though the suspect in that incident was unarmed. We went over the reasons for that. And, some people might be surprised to hear that, this is actually justifiable. But we went over why. This week, we're kind of doing the exact opposite, right? Where we're talking about a shoot here that you guys actually took a very bold stance on in the headline for this video, but basically a bad shoot, right?
Yeah. So for the folks at home who've never heard the terms good or bad shoot, I just want to clarify. Steven doesn't mean it's good that someone got shot. Obviously, that's not what I mean. What that means is, was it justified or not? That's a pretty common term in law enforcement. It was a good shoot or a bad shoot. This is a bad shoot all day long, every day of the week and twice on Sunday for a number of reasons. The individual that was shot was having some sort of mental episode. This is, I believe, in or near Houston or Harris County, Texas. And he was clearly having some kind of mental break, or was potentially high on narcotics, but not acting rationally. He went to a gas station in the wee hours of the morning and started sort of dismantling all the pumps, taking the sort of fascia, if I recall correctly, off of the pumps. And those pump hoses can be pulled out. That's by design, in case you drive off, with the thing still in your gas tank. Those be pulled off. So he's creating all sorts of mayhem. But you can't commit violence to an object, right? So he hasn't really done anything violent yet. They came
sort of vandalism, basically.
Yeah, but they came in real heavy, like way heavier than they needed to. And I think everything they did leading up to the unfortunate events was kind of precipitated by the cops, who kind of raised the temperature unnecessarily, both with their tone, with their language. And I'm not a prude, right? I've shouted the F word when it's necessary, but when it's not necessary, it looks bad, right? And so, as I always say,
it can be escalatory, right?
And also, depending on how this ends up, and this ended up poorly, I think, you have to, as an officer or a deputy, you have to ask yourself, how is my behavior going to look to a civil jury in 3 years and 5 years when I have to defend my actions? How is that going to look to, the PTA president who's been called to jury duty, who's not in your world and doesn't understand this stuff? It's going to look really bad. You're going to look like the bad guy. So that's one of the reasons I avoid the language unless it's really necessary. And usually it's not necessary, in my opinion.
And so these two sheriff's deputies show up on the scene at this gas station, and it's deserted other than this guy, this suspect, and I guess an employee who had called the police, but the employee's not out there when this encounter happens. No. So it's just the three of them. And they show up, they confront this guy. Initially, he's cooperative. We'll watch part of the video here. Now, this is a 20-minute video, just so people know. It's got a lot more analysis and detail than what we're going to get into. So we definitely encourage you to go watch the full video over at the Active Self-Protection YouTube channel. But we will go through some of the key parts of it and get your explanation for what's going on here and why you guys said in the headline that this not just a bad shoot, so to speak, but should be criminal. Criminal charges ought to be brought against this officer is the conclusion you guys came to.
Yeah, and I was going to say, I don't think, I could be wrong. I have to go back however many years we've been on the air. But I don't ever recall an occasion where both John and I said, this is 100% unjustified. This is actually murder, and the person should be charged. It's the first headline or title I can remember where this should be criminal charges against this officer was ever used, in my experience.
Yeah, and so and this resulted in the death of the suspect. So
correct.
Very extremely serious situation. But we'll show you how that it got started here, which didn't start off at that point, right? It starts off with the suspect. On the ground. That's where we're going to start. He's on the ground. The two cops are talking to him. He's there. He's got his hands. He's laid out. They're going to
Put your hands behind your back. Now.
Apologies for
Get on your
the
stomach.
language.
Get on your stomach now. Get on your fucking stomach. Do not move. Do not fucking move. Do you hear me? I will tase you. Put your hands behind your back. Put it behind your back now. Get on your stomach.
All right. So that gives you an idea of the beginning of this. He starts off complying, then he's not complying so much. As soon as the handcuff goes on, or at least they get one hand behind the back, then that's when the real pushback begins from the suspect. He sounds from the video that he gets tased there. That does not bring him into compliance, though, right? What happens? First off, what were just the real quick takeaways from that first bit of interaction? So they had him on the ground. This could have ended, right there, right?
Yeah, I think what we're seeing here is either a lack of training or just people just not following the training they were given. I don't know how they train their deputies down there, but when my old agency, all my old agencies, we had defensive tactics refreshers. So everything leading up to this is a poop show. Everything their tactics are not good. She's standing over top of him instead of being knelt down in a more secure position. He's at no point did they complete. We call it a position of advantage and a position of disadvantage. You want to be in the position of advantage on a suspect. He put himself in a position of disadvantage for them, and they walked up and instead of just doing the thing, right, getting down, putting a knee on his shoulder, pinning his shoulder, and putting his hands behind his back, they stood over him. That was ineffective. She puts one cuff on and starts asking for the other hand. And something Stephen actually picked up on that John and I hadn't noticed, potentially the deputy holding the taser may have accidentally activated it. That's a possibility. I'd have to go back and look at it again.
It's hard to say.
They could have initiated his resistance because he's being tased for no apparent reason. I don't know if you saw it.
Yeah, and I don't know exactly when that taser starts, but certainly you could see, if you go and watch closely that video that we just showed, he's allowing her to put his hand behind his back, and then suddenly starts yelling in pain. And around that time is when you can hear the clicking of that taser go off. And so it's not clear to me whether he got accidentally tased and that's what made him react that way, or if, because I imagine in your experience, this is sometimes suspects will react that they'll pretend to be hurt, or,
right,
whatever. And I think you had mentioned in our talk before, sometimes people can be compliant until the point of the cuffs starting to go on, and they sort of dawns on them what's happening, that they're actually going to be arrested and taken to jail. That's a potential point where they might start to resist. So
correct.
It's not clear to me whether which thing is happening there, whether the taser's what caused him to yell and resist, or whether it's just the officer reacted to him yelling and resisted by tasing him. But so that's an interesting question. To be good to figure that out. Hopefully, if there's an investigation, and then we'll get to the outcome of this later at the end. But that might be something worth questioning here. But either way, the result is that this guy refuses to comply. He starts to fight with the male officer here, right?
Yeah, I think you put it best. He really wasn't fighting. He was resisting and more wrestling than anything else.
Yeah.
I don't recall seeing any punches thrown. If there were, my apologies in advance. Mm-hmm. I wanted to reiterate something you said a moment ago. I was a trainer for many years with my agency, and defensive tactics stuff, I would tell my young agents, listen, as the person is going into custody, they're complying with you. That moment when they feel the cuffs about to go on is the moment. If they're going to change their mind, that's the time they're going to do it. So you need to be on your P's and Q's and do everything you're going to do quickly and swiftly. That didn't happen here. So now we're in a wrestling match, and for some reason, the male officer doesn't appear to have a lot of training or isn't following his training in defensive tactics. He's not effective in what he's trying to do. And then even worse, his female partner is absolutely 100% useless. She's running around. She steps on his shirt at one point to try to gain compliance. And I just didn't see her do one positive thing this entire interaction. And the idea, and then, obviously we know what happens then is extremely unfortunate, and I thought unnecessary and unjustified. Just in my opinion.
I mean, people, again, I think people should watch the full video over on your channel, but the point between when he starts to resist somewhat vigorously, he's not throwing punches, but he's clearly resisting. He's not complying. He's sort of physically wrestling with the male officer. From that point on, like all the officers, both of them just seem totally out of depth in this situation. And I think it leads to what ends up happening here. And she just seems like she had no training at all or whatever. I don't know, but shouldn't have been out there is, I think, the clear indication watching this video. And specifically for what we're about to watch here, which is, again, content warning on this stuff, not just curse words, but this includes someone being shot and they do pass away. It's not graphic, but it is, still a harrowing watch, of course. So just, if you're not interested in seeing that, feel free to tune out at this point or skip ahead a bit. But here, what results in is there's, they wrestle, there's yelling. She's sort of just standing off to the side, telling him to comply. And then it leads to this. This is from her body cam. The first one was from the male officers. This section is going to be from hers. So we will take a look at this key point in the video where the actual shooting occurs.
Let him fucking go! Let him go! Oh my God, I don't want to fucking shoot him. Let him go! Oh, Korea, I'm gonna have to. Are you okay? Are you? Did I hit you? Sit down. Sit down. Don't fucking move. Don't fucking move.
And we'll also get the security camera view here in a second.
I need y'all to hurry up.
Here it is. Okay. All right. And so obviously never easy to watch someone get shot like that, but boy, hard to see justification in really either of those shots, but especially the second one, right?
Yeah. As we talked in our pre-brief, I said in the original video, I'm like, look, if you have some other angle of this that we don't have, that shows him armed or somehow, an actual threat to someone's life or, a threat of great bodily injury to one of these officers or a member of the public, please send it to us. And that might justify that first shot, maybe, kind of, sort of. I doubt it. I don't believe so. I don't think that exists. I don't think it's a thing. However, nothing anyone can show me can justify that second shot. I don't understand what she was thinking, what was going through her mind. I think this sort of thing is really eroding the trust of American people in our law enforcement. This sort of thing is happening. Unfortunately, it feels like, and maybe it's anecdotal, a lot more than it used to. And I don't know why that is. I don't know if training has gone downhill, or I know a lot of agencies are having a really hard time finding people, qualified applicants, and getting them through the process. When I started in the 80s in law enforcement, there was something, most places where you'd want to work had something like 400 or 500 applicants for each opening. That was how competitive it was back then. And yes, somehow I still got hired. And nowadays, my son works for a local PD here in Southern Arizona, and he's telling me that they're basically desperate for people. So I can't help but wonder if that isn't part of the reason why we're seeing this sort of uptick in excessive force and unjustified shootings. The last thing I wanted to point out is, listen, everyone who worked with that deputy knew she was probably not cut out for this job. And I just feel like if you're out there in a law enforcement agency, especially in a position of authority over hiring and firing, you can't let these sort of people, and we've all, any cop who's worked for any period of time will tell you he or she has run into an officer or a deputy like this. And you're like, what are you doing in this job? I think we need to be more proactive about either finding another job for them to do in the department that doesn't involve, badges and guns, and let them go do that. But we can't continue to allow this sort of unqualified person, and they're out there, to continue to patrol the streets, because this is the result, unfortunately, increasingly more often, I hate to say it, than it used to, in my opinion.
Yeah. Yeah. I mean, you watch that video, and I think the security camera footage gives you an even better, probably the best view of, the most definitive view, which I guess, to be fair, the woman who pulled the trigger here couldn't see from that. It's from the other side of her point of view. Now her badge cam obscures is partially obscured by her, her radio. So, that part is not as informative, but you can clearly see on the security footage, at least to my eye, that this suspect just didn't appear to be reaching for the other deputy's gun or have any sort of weapon on him. And I mean, they're literally just sort of wrestling. It's not, it's sort of physical force, taser, pepper spray, that all seems like it'd be well within reason to use here, but deadly force is such a stretch that, I mean, I think you guys are right that should be a criminal, especially that second shot. I mean, the second shot, he sits up and looks at her and his hands are visible and they're empty. What possible justification could there be for that? And so, I mean, that's your basic read on it, right? Yeah,
it is. Gosh, I had a point in my head I wanted to make and I forgot it. I think the important thing to take out of this is that channels like ours I think active self-protection is as fair-minded as you're going to find in the self-defense and the law enforcement arena. There's other channels that are super pro-LE, other channels that are super anti-LE. Our comment section is usually 50-50 on any given law enforcement video. Half the comments, you guys are all, statist, bootlicking, subservient, and you love the cops. And the other half is you guys are anti-LE and you hate the cops. And that's nothing could be further from the truth. But I think this video in particular, the comment ratio, I don't have an actual number, but it seemed like 500 to 1. This was clearly unjustified, which is pretty rare in any comments of any YouTube comment section, in my opinion. So we try to call balls and strikes. And that's what we did here. And that's what we're going to continue to do, hopefully.
Yeah. And that's the other thing that sets you guys apart in my book. Not just that you're using, real world videotaped examples of situations that people can learn from and draw concrete lessons from, but also that you do your best to view things from a fair and nuanced point of view, and you're not just trying to shill for one side or the other, right? That's the other thing that where I see a connection for the Reload and ASP is just that sort of approach. That's what we're trying to do the best that we can, at least trying to be fair. So look, I appreciate you joining the show again here. For those of you who don't know, Mike and I do a show for active self-protection where we do a little, we talk about the news for their audience. And so, it's nice to once in a while to do this crossover where you come and talk about self-defense incidents or police involved shooting incidents for our audience. So thanks for doing that.
Absolutely. It's a lot of fun. And come check out Stephen over at the Katowski Files over at the Active Self-Protection Podcast, where all fine podcasts are to be found. They're not sold, I guess. Yeah, you get the idea.
Well, there is a ASP Plus, right?
The app, yeah.
Which you can get a lot of additional exclusive content from there if you like what ASP does. And it's something that I highly recommend. And so where can people find more ASP stuff if they want to do that?
Yeah, I mean, if you go to activeselfprotection.com, there's all sorts of things. I always want to get in a plug for our conference. We have a conference every September near Manhattan, Kansas, in the Flint Hills. It is a conference with some fantastic training. It's 3 days of training. And the whole thing is no one gets paid out there from any of the instructors. They all donate their time. It benefits the Flint Hills Foster Teen Camp, which takes foster teens that otherwise would not, probably almost certainly would not have a summer camp or a summer vacation experience. And many of them are told for the first time that they're loved, that they're worth something. So it is a fantastic cause. So I'm pretty sure we still have openings. So if you're interested in really good training, benefiting a really good cause, go check that out as well.
Awesome. And of course, people head over to the Active Self-Protection YouTube channel, and we'll put a link to this video that we were discussing today. There's a lot more detail a lot more specifics from John and you in the full video, so people should check that out. But that's all we've got for you guys this week. We will see you again real soon.
No, the devil's got no